We have dismissed this petition on the ground of locus, but we have made certain observation. It is, however, made clear that the dismissal is only on the locus of the present petition and may not be an absolute bar for an appropriate person to question the appointment of the respondent number 4 as the chairperson of the commission by the order dated 11/3/2024. Writ petition accordingly stands dismissed in terms of the observations made above.
Seven 2017.
We could not accept your plea. We have dismissed it.
Item 24 WBC 760/2017.
Signing for us, signing for you.
sign কৰিছিল
Sign for 9. Same fate. Dismissed. Yes. When? Day after tomorrow is Thursday. Wednesday is tomorrow. Oh. Friday, okay.
judgment দাদা এই হেইটো না লিস্টখন নাই
19 and 20.
লিস্টখন নাই
Yeah, for the respondent.
ৰিমোট আছিল
21 matter, madam. Why should you grant you time? You have to get the instructions in the last 5 years. 5 years you are not able to get the instructions. How do you get the instructions in one day? What were you doing for 5 years? Sleeping? Deep slumber? Not 2 weeks. 21 matter. How do you expect 2 weeks to be granted? 21 matter. Victim company, you have to pay if you are not responding in time. We'll grant you 10 days time. Get the instructions, 10 days time. We do not know. 21, you have not done anything. We are granting you 10 days time. On the request of Ms. M. Devi, Learned Counsel, appearing on behalf of the state. Matter is adjourned to be listed on. We give you a date. Today is what? Today is 5th. We'll have it on 15th. 15th. Okay? Okay, 18th. Almost your day which you have paid for. 18th. Yes. But last opportunity. Okay. 18th. For instructions. 18th for instructions. Day 19 matter. Why should we adjourn? Okay, we give a date next Tuesday. On a request made by Sri A.A. Diwan, Learned Counsel for the petitioner, matter is adjourned to be listed on Tuesday next. Please give the date. 12 May. 10th. 10 May. Okay, 10 May. Very good. 10 May.
10 May is a Sunday
11 May.
আধা মেটারটো কি আছে
Itu.
1920
23. 22. On behalf of whom? For the petitioner. Where are you seeking adjournment? Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Monday next. Oh, after 1 week, Monday next. Today is 5th on 11th. 11/5. Yes. Yes. Item 4, 19 matter. We'll have day after tomorrow. Okay. Request for adjournment has been made on behalf of the petitioner. Full stop. Considering that this matter is pending since the year 2019, a short accommodation is granted directing listing of this matter on day after tomorrow. 7th, no? 7th. 7/5. Yes, Mr. Atia. Why are you seeking time? When? Monday? Next? No, not 10 days. These are 19 matters. We'll accommodate you Monday. Okay. But your name is not there. Item number 8.
10.
Oh, 10. Okay. We thought it. On the request of Sri A. J. Atia, Learned Counsel for the petitioner, matter is adjourned to be listed on Monday next. Give the date, please. Monday is 11. 11/5. Okay, now 11. Yeah, बहुत की नहीं.
Item 1. In this case, that part of the very we want to go in
Delay.
here the case is
Delay नहीं की?
this is
Materiality of the procedure reference to report job नहीं किया.
and here report that here report. I will kindly have a look at annexure 1.
Records. Records to do.
Annexure 1.
No, record.
No, I have to.
Oh,
Okay.
अच्छा. That's there. Annexure 1. Is Sonia Khattur.
This 20 plus equal based on e-booker. Because this, I may have looked at minority and new report. Completely blank except only filling up the 3 columns, 4 columns. Name, then village and husband's name, there of birth. Nothing is mentioned. The other columns, which are columns of blanks. And the column 15 and 16. Very important column. That is, there is no categorization of the period of 20. Whereas the petitioner is clear on that. After marriage, he has been deciding in a parental house, mother and father.
After marriage,
Yeah, after marriage.
she did not shift to the matrimonial house.
She is deciding in the matrimonial house, the parental house.
That means she all along she has been residing in the parental house. She never shifted to the matrimonial house.
Marriage was really happened and my lord coming to husband's house, then therefore
That is not a shift. That is only for the purpose of solemnizing the marriage. But she never stayed at the marital house. Okay.
she has lived that in the matrimonial house and she has been all along Bhuta with mother and brothers. And the LBO report goes to show that this is completely blank. There was no spot verification. As per the notification guideline of the digital case, there shall be a spot verification. This cannot be said as a spot verification. And when D is marked against her name, given an option. Marking D against
Opportunity has been given in the reference.
no. In the investigation stage also.
Is it? Okay.
That is the guideline of the debuter case. In the right of the Lalgam Hussain case.
Let us see.
Lalgam Hussain case says that
Citation.
My lord, citation is 1995 PSCC.
1995.
1995 PSCC is 100.
But the voter came after 1997 intensive revision. How is this?
It came already principle laid down in Lalgam Hussain. That also been mentioned in the guideline.
Let us see what is which paragraph.
Paragraph But, paragraph 6. Where you got
Yes, please.
paragraph 6. From the aforementioned provisions of
Did you give a list of books? You are not giving the citation. You have not given the list of books. How do you follow you?
last week I have to then I the item 1 and also
It's difficult to follow a citation.
financial requirement matter will be taken up after some time.
The double sense exposure is. About issue of double sense. 6 foot of this.
Let us furnish the least value up to let us.
This is 7174.
We do it, my lord, we are ready.
No, you can read it, but you should. 7174.
What is the paragraph? What is the paragraph?
16.
6.
6.
How does it start?
Paragraph 6, may I read? From the review of
Hmm.
the aforementioned provisions of
Sabha.
it's clear that whenever any authority is called upon to act on limited purpose of another law, whether a person is or is not of citizen of India, the authority must carefully examine the question in the context of constitutional provisions and the provisions of the citizenship that expected herein before. In the instant case, Article 5 of the Constitution provides for one general electoral rule for any territorial constituency, so does Section 50 of the 1950 Act. This has to be done under the superintendent's direction and control of the election commission as per the mandate under mandate of Article 324 of the Constitution. Section 50 of the 1950 Act in terms states that a person shall be disqualified for election in an electoral role if he is not a citizen of India. But positively, a person must be citizen of India entitled to refuse to the electoral role. Subsection 2 of the said section empowers striking of the name of a person who incurs disqualification such as clause A, B, C, or subsection 1 after his name is entered in the register of electoral groups. Otherwise, any persons who is not less than 18 years of age on the qualifying date and is ordinarily resident in a given constitution entitled to be registered. Section 22 empowers the electoral registration officer for a constitution to delete entry already made if on inquiry he is satisfied that it is erroneous or defective in any particular or needs to be transposed to another place in the role, or the person concerned has died or has ceased to be ordinarily resident in the that constitutes or that is otherwise not entitled to be registered. Of course, before any such action is taken, the person concerned, except in the case of death, must be given an opportunity to be heard. That is our point. How the opportunity was given while D is marked against my name. That is my point. And, the concluding part of this judgment is very important. The similar minor direction was reflected in under paragraph 13.
But these submissions have been answered in many other cases. Not the first time you are making this submission.
This is a Supreme Court decision.
No, the submissions which you are making on the voter and the procedure to be followed, these submissions have been made in other cases, answered by this court. Why are you making the same submission?
Yes.
You have to place those judgments and make out why should we differ from the
Should not be utilized by this type of investigation, and that has been the decision in the case of my lord. There are so many judgments, but I want to refer this one. WBC number 3230/2020.
WPC 333
2020. Rofika Bibi and Rofika Khatun.
Rofika
Rofika.
spelling
RAFIKA. Rofika Bibi and Rofika Khatun. It is a judgment dated 26/5/2025.
26/5.
Hearing this case, my lord, so many decisions have been discussed, including the rural judgment. Particularly the paragraph 96, 97 of rural judgment, 98. Regarding the fair trial and fair distribution. Paragraph 31 of the judgment is very important. Where is my paragraph 31? Having regard to latest available in resource in the light of the objection made in the case of Muslim Mandap, whereof the proceeding initiated by the tribunal cannot be sustained for the following reasons. There are no specific finding by the executive authorities that the foreigner migrated from the specific territory and Bangladesh. Enquiry authority specifically stated in the report that critical was not available in her address as reported by their neighbor that she was working in a big field at the relevant time. Even if the referral authority, in spite of the finding of the inquiry authority, decides to refer it to the tribunal, it must give positive reasons to justify the reference on account of specific finding recorded by the inquiry authority against the person which we find it to be totally missing in the present case. The reference was mechanically made and suffers from non-condition of mind. Even if the reference has been made by referral authority, contrary to the finding of the inquiry authority, it was incumbent on the tribunal to specify itself about the existence of the ground for being referred to. The tribunal cannot mechanically act upon any reference without examining the materials on record. The reference made by the level authority cannot be mechanical, as held by this court in the case of Muslim Mandals. On parallel to proceeding, the tribunal would not see any exercise being undertaken by the tribunal. That tribunal was primarily satisfied about the existence of main grounds on the doubtfulness of the nationality of the proceeding notice. Therefore, keeping the aforesaid principle laid down in the case of Muslim Mandals, we have no other option but to put that the tribunal made an error in proceeding against the petitioner, as was no any specific finding right at the actually approved that the petitioner is illegal.
When you have judgment, it is done to go away even if there is no reference in a particular way. It is like deciding on that subject only.
Ultimately, the question is whether we have given a fair opportunity to defend. That opportunity will come when you are having a proceeding, a judicial or a quasi-judicial proceeding. Now here, the initial investigation, just like police investigation, you make some inquiry. And even if you presume that the inquiry has been perfunctorily done, that inquiry is only to give a safeguard. The other mother, they'll proceed because the reference is already there. Before making the reference, LVR is always a local person. He doesn't belong to the either to the electoral office or the DC office. He may be an Indian citizen, may not be a foreigner. So then you give a chance that foreigner get out police or the he gets a full chance. It here, it isn't to say. Adjudicating authority reference to calculation as one but আমি রেকর্ড বুঝি পাবো
এখানে যে একটু নয় যে খালি খালি যে
না এইটো আমি এইটো চামতে কাইন যদি হয় this is what is this in 1997 there is an intensive revision where many doubtful voters were found and before deleting electoral officer they collective Amis will make another stage to see whether there is any other material to show that they are Indian citizen. It will take on a not to show that he is a foreigner, to show that he is Indian citizen. So you proceed with this. Then you give a chance. Chance to pass out. Chance to get out. In the tribunal, you get a full chance.
It is a chance to.
It is a chance of what's happening. It is a chance of what's happening.
यहाँ से की बार देखा ले आओ 95 और
Sign on it.
मैं तो बिल्कुल बुझी ना बोलूँगी
Sign on it. Yes. But this submission has not been made for the first time. And
it was
again, the period that this purpose has been answered in a number of cases. Yes.
This is clearly covered by this and in the case of here there was no investigation, only a new report was mechanically prepared. Even it does not go to show that LBO has visited her house. And in fact, she was not in her matrimonial residence. She was in her parental residence. And therefore, nothing is mentioned with no specific start relation. The column 16 is very relevant. It is suspected to be suspected foreigner. What category of foreigner and which period she has entered? That should be specifically mentioned. That column is also blank. Column 16 of the LBO report. Not only 16 blank and entirely blank except one. So this cannot be said that there was it is in the name of the case also. And the tribunal has also ignored to look into this aspect, whether there is any charge against this person, whether there is any materials in this person. Nothing that this has not looked into. in the light of the paragraph 98, the tribunal is to satisfy itself about the existence of the main grounds of such. Paragraph 90.
Have you enclosed the referral order by the Superintendent of Police border? This is the LVO report you have enclosed. Where is the referral order?
Now we are not enclosed.
Is it available? Is it available with you?
It will be in the record.
Okay.
If there is any order, but we have only annexed the
LVO.
and the notice. That will be available in the record.
That is most important. Referral order.
Reference of the Superintendent of Police
Yes.
order. It was in the record. It is actually okay. So we don't just somewhat on of Dinga. Yes, spoken of Dinga is our parental district, our maternal one. For deciding these are responsibility status under the Act 92. State thereafter as per the report of PRO, there is no reasonable doubt whether the person is in India or not. While this line is very important. As per report of PRO, there is no reasonable doubt whether the person is citizen of India or not. Hence, it is ordered to be foreigners tribunal for its.
Where are you reading from? Where are you reading
There are
from?
14 of the records.
Oh. Referral order. Mm.
It is submitted that the case was initially ordered to be obeyed by the ERO concerned for determining these and responsibility under IMDT Act. However, by that time, IMDT Act 1983 has put made appeared by the Honorable Supreme Court by order. Accordingly, the case was forwarded to the FT case is published by FT numbers was sent for field inquiry. Was sent for field inquiry. However, there is still pending due to non-compulsory. That means I was not charged. I was not made by the inquiry. This case is still pending due to non-compulsory of the deep-rooter concern. I was charged in my matrimonial house. I am residing in my husband's house. I am residing in my matrimonial house. I was charged in my matrimonial. That is the result. It reflected. That means there was no investigation, no personal interrogation, nothing else. No spot verification can be made in this way. So this is a case where this reference was made mechanically without any prior investigation, without giving opportunity to prevent at the investigation stage, and the tribunal has taken cognizance of the case without satisfying itself about the existence of the main grounds. That is my point. And therefore, the light of the Robita case is a mechanical reference, it cannot be sustained. That is why I maintain it under their submission.
Today, if one maintaining it goes, we need not go into the matter.
That was very long.
Oh.
I'll prejudice with them
Mm.
if we don't accept him and everything. Otherwise, if he has a good case.
Mm.
Yes.
Apart of this merit of this case, on the maintenance petition, my lord, what is submitted before the tribunal, watching may kindly have.
Can we see the documents?
Well, yes. My doubtless is actually 32. It appears that it was well pleaded doubtless, and the point of that in the verification has also been made in paragraph 2 that there was no proper inquiry and verification by the LU. And my documents also be fine. And then sir, the school certificate, exhibit was agreed, at case 40. School certificates. Usually. School, exhibit page 42, NSR 4. Then my lord, NSR 5.
Just a minute. School certificate is page.
Is
Just a minute, please. 42. What is the date? Date.
26/11/2010. Certificate dated 26/11/2010. He did and Prathamic Vidyalaya up to class 2. 1991 December মাহ অনুষ্ঠিত নিম্ন প্রাথমিক উত্তীর্ণ হয়েছেন আনুষ্ঠানিক বইপত্রের জন্ম তারিখ 15/8 yes 58/1983. This is the school certificate.
You left school on জন্ম তারিখ জন্ম তাৰিখ বিদ্যালয়ৰ থকা কালত তেওঁৰ স্বভাৱ চৰিত্ৰ ভাল আছিল, পঢ়িছিল। ডিচেম্বৰ মাহত অনুষ্ঠিত নিম্ন পৰীক্ষা। You passed what? Which exam? Class 2. In 1991.
ডিসেম্বর মাস অনুষ্ঠিত নিম্ন প্রাথমিক পরীক্ষাতে উত্তীর্ণ হয়েছে। বহিঃপত্র মতে জন্ম তারিখ 15/8 by the headmaster on 26/11/2010. And headmaster was there.
Headmaster S. DW.
DW.
But this fact, which has been certified, is of more than 2 decades. Data of she read in class 2 in 1991, and this certificate has been given in November 2010, almost after 20 years.
For that, this validity of the certificate will be negated when the master has come and.
He deposed as DW.
Four. DW 4.
No, PW.
Wait.
No, my order publish.
Yes, sir. That is, Mission register is also produced. And as for the tribunal rejected this proposal because the counter signature of the PO was taken in the year 2018 later on. Right? Even if the counter signature of the PO is presumed to be not there, but assuming it is not there, the headmaster came forward and adduced evidence, produced the additional register. How this entire evidence can be negated? Is it not, my lord, gross injustification? Where read the manner evidence of the school headmaster.
Yes.
That is 101.
Hmm.
I am the headmaster of the School of Golconda working since September 2010. I have received someone from the tribunal. I issued the exhibit A certificate in the name of Samia. Total of Ahmad Ali. Village Lake Park is Portland district. Golconda. The opposite party was admitted in our school on 5/1/1990 in class 1. On the date of admission, she was 4 years old, and her date of birth is 58/1986. Opposite party submitted an application on 15/11/2008 for his certificate in academia. The certificate was issued on 26 days. The counter signature view was obtained on 7/8/2016. I have brought the counter view this certificate and petition register. Petition register was there are the name of the opposite party is referred at 10,205 dated I-190. Technique A1 is my signature, technique A2 is the signature of the block. At serial number 2,205 dated also the name of Samia Begum, daughter of Ahmad Ali, is recorded. I issued exhibit A certificate in the name of Samia Begum. There is little variation. Admission register, her name is Samia Begum, but certificate Samia. And these have been picked up at the last tribunal. And the counter signature of the PO was given later on. These are the grounds. And when the admission register is here, admission register is used. Whether this part can be taken as an rebuttal evidence.
BE of countersigning derial ki hal ke
Only variation of
Aforesaid suppose.
There are so many decisions of this one court and the Supreme Court that minor inconsistency should be ignored. Name discrimination is discrimination.
Interesting.
And these are
Just a minute. It with a application from was applied for when she was facing a proceeding under MDT. 15/11/2010 reply করছে 26/11/2010 issue করেছে subsequently কেতিয়া কৰিলে 18 ওচৰত কৰিবলৈ কি হ'ল DO has also come. The BO
has not.
he has not come.
Only head. So when a third party admission register that has been proved beyond any contradictory.
Except the inconsistency in the names of the
Yes.
petitioner as well as father.
Admission register, others name is, there is no any contradiction. Other name is Ahmad Ali, all alone. So now we want to draw your attention to the documents. We see documents. Then say the of grandfather. And it's a right page 40. Because of dated 25/8/1962. But then grandfather passes land from Manmohan. This protection in favor of Mohammed Sanu Sheikh, son of Somer Sheikh, bypass Muslim profession for resident of Kolodi, Nespara. He is registered and the corporate executor Mohammed Ali, son of.
What is the name of the grandfather?
Grandfather Kanu Sheikh.
Kanu Sheikh.
Yes, grandfather Sumer. Sumer Sheikh or Sumer? This was exhibited and next I will vote that this is not proved in proper way as per law because the documents is to be proved by calling this part it is a document more than 30 years old. Certificate to be of 30 years old document not required to be proved in the light of section 90 of the Evidence Act. Then my lords, book a list of 1966 at page 61. 61 is the particular. Translated copy here. Aforesaid is my grandfather. Aisa Abdul is my grandmother. Abdul Sheikh is paternal uncle. Amdad Sheikh is paternal uncle. Sulani is paternal uncle. Then my lord, it was exhibited as exhibit C.
1966.
1966 of village borrowed money. Village borrowed money in the land documents also. Village borrowed money. Residences, residential address borrowed money. Then my lord, Bhutta list of 1970. It was executed as
Just a minute, please. 70. Kanu is your grandfather. Aisa is
grandmother.
grandmother. Abdul,
Here, paternal uncle.
your father is not here.
Father is not here. Father came later on.
Okay. Uncle is Abdul is your uncle.
Sheikh and Abdul Sheikh. The Douglas also mentioned.
And Sonibi Nisa is Abdul's wife.
The wife of
Abdul, okay. And Amzad.
then the 70 Gupta list was find in page 53. Exhibit D. Same person. Other is not here.
Amzad Sheikh.
Other is available in Gupta list of 1960.
And this was Annex C. Exhibit C.
Father and mother both are
Just a minute. 53 is voter list of 1970. Kanu Sheikh.
same as 66. It was executed as exhibit D. Of village development store.
Okay. Then when did your father came into the scene?
Page 54 and 55.
Correct.
Was agree that here my grandfather is there, my father, mother, both are in same village. I'm Sheikh, Thomas Sheikh, Ahmad Ali Khan, Asya is my mother. I have Ahmad Ali. In brutal list of 1985 at page 57. My grandmother was missing in 1929 visually, but evolution take to brutal list. The brutal list, Ahmad Ali, my father, Basya Khatun, my mother, Aisha Brava, because our grandfather died. Aisha Brava. Here, grandfather's name is mother. There is a creation. Instead of Kanushe, it is written as Kanushe. Then, my lord, on Kiraz Vedi Kata Patta, in the name of my father, it is at page 59, Ahmad Ali Kanushe.
Just a minute, please. What is the name of the village?
It is Dekdua. There is a shifting, and that has been stated in the place.
No, at page 57.
Yes.
Which is the
Yes.
village?
It is Dekdua, sir.
No, that is the voting center. What is the residential address? Which village?
Dekdua. But in 57, Lords will find Gau 44 Dekdua. And the shifting of the family has been stated in paragraph 12 of the document. The Takanda family shifted from
এটা কোড তৈরি আছে ভিলেজের নাম কোড আছে এটা কয় না এরকম
দেখো আছে বাবা।
জিলা গোয়ালপাড়া
Wait,
ও ইয়েস
wait.
গাঁও দেখো
It's, there were-
they are in Colossus.
Yes.
The Katapasta, it was executed at the G at least 59. My lord, the list continued to be the same. Dekdua Chor is 62. The total list of 1997. total list.
Just a minute, please. What is this? What is page 58, 59? 59 is what?
After. For the paying revenue.
What is the date of this? Acha.
Nine 1994.
20?
2009 1990. Settle.
এটার কি রেলেভেন্সি রাখি 94 বাপেকে কিনা মাতি নাকি
পেপার নাম তো আছে যে
আহমেদ।
মাতৃ সংক্রান্ত।
আহমেদ আলী son of কানু শেখ।
Next. Yes, next.
The total list of 1997 is 60. My mother and my sister. Sunabhu.
This is exhibited? No.
Here, we are not at as an exhibit. We will not be able to take it. But so, therefore, we say.
বাপেক মহিলা চাগে কিবা
But Sona Bhanu, how is she connected with Sukur Ali?
My sister.
And Sukur Ali?
My sister husband.
No, how, she's with your mother. She is not shifted to the matrimonial house.
Maybe for any reason she was staying at that time with mother. But in the subsequent list also, husband and my sister both are my parental family. And also coming subsequently.
so parent family তো থাকে নাই so
2005 total list, Sunabhu is there, Sukurali is there. Sukurali is the brother-in-law of the sister. Is the son of Muslim one. And Sunabhu name has been mentioned in WS, paragraph 6. That Sunabhu is my sister.
Where did you appear?
My appearance in, I mean, the letter was.
But this Sonabanu 1997 is not exhibited.
Hmm.
I don't know, my lord. 2008.
H.
Yes, 2005. Sorry, 97 voter list executed and exhibit H. 2000 voter list, 2005 voter list executed exhibit I. Exhibit. I voter list was also exhibit.
Fine.
2005 is exhibit I.
I did.
No, 2005 voters list is exhibit I.
But then I,
64.
2005 is exhibit I.
This from here. That's alam. Itu কোন আছে? বাদশা আলমগীর কোন আছে?
বাদশাহ আলমগীর পিতা মোহাম্মদ আলী ফুটে।
25 বছর।
So brother-in-law is his name is recorded with the in-laws family, right?
Illness. Total is my brother. Son of Sulaim Ali.
Probably. Probably some. 86 born, right? 86 born.
86 born.
So 2005 what kya hane namke?
2015 ওটা হয়েছে গো।
Your name in 2005 voters list?
Yes.
Your name?
2011 voter list.
No, 5.
I voter list.
19 years হবো না এটা?
I am not.
You're 86 born. You're 1986 born. So you have attained the age of right to franchise.
But my name is in the voter list of 2011. 2011. Find that case.
Now what about 2015? What is this?
Voter list of my matrimonial house where I have to mark and see. Voter list.
You are in serial number 3.
I am in serial number 5092. 559.
Huh.
My mother-in-law at 547. My husband 548. Here I am ready.
But Roop Bhanu Nessa in the earlier list was wife of Omed Ali.
My mother-in-law.
Hmm?
My mother-in-law.
But see 2005 voters list. Omed Ali is said to be the son of Ahmed Ali. That means your brother.
So the five people list, yes. Here. This one is not in 2005.
Is there the last name?
One is Ahmed Ali. Oh, this is a different person. This one and the voter list of different person. Ahmed Ali is my brother.
Hmm.
And Rubanu is my brother's wife.
Hmm.
Here Rubanu Nasa is 40 years. And here Rubanu is 3 years. My mother is. In my matrimonial village.
But this is not a certified copy. 2015.
Next, only to clarify that I was with register in my matrimonial house, which was not known to me. I was unaware of the voter in my matrimonial house because my in-laws has proposed to enlist my name in the voter. This was not known to me.
Was this exhibited?
It was not exhibited because it is the voter certificate. It is annexed in the record. It is available, and also I voted in 2011 with my mother. So in my matrimonial, my mother's house, they got 2011, 2017. I'm with my mother.
2011 you are
Yeah. Other thing. Because the village inseminating people is of somebody safe. The other family members have said, but certificate singly. 17 total is also to find that this is the entire family is there, same house number. My mother, Vasya Gawa, Bhanu, my elder sister, the her husband, Gurali, Bacha Alamgir, my brother, then Umadal is my brother, Islam, my brother. We are upon my name, Elder Islam, brother, Islam, my brother. So the 11 total list was executed. It was 17 total list. I executed the executed. I am mother and brothers. My mother and brother are examined also. And then
Link থাকা লাগে দেখুন রিটেন In paragraph 18 of the written statement, you have written that your name appeared in 2005 electoral roll with your husband.
That's, but no total list of the.
Huh. But that is your pleading.
Petitioners have been respondents and no total list of items.
That's a pleaded case. তেতিয়াহ'লে ঠিকে আছিল 2005 যদি তাই ভোটাৰ্ছ লিষ্টত আহিছিল 19 years গিৰিয়েকলৈ ডাঙৰ বুলি কৈছে পিছত আকৌ পেটাৰ্ণৰ ফেমিলি হৈ গ'ল
And next,
5 we have annexed, but 5 does not contain your name
Hmm.
at page 64.
this.
Page 64. It contains Basia, Bacha Alamgir, Fatima Ahmed, Robikur Islam.
This my name is not here.
Not there.
This is your paternal family,
Side.
but it is said your name appeared with your husband.
Here are total list of 2005. That's what statement in paragraph 18 of the WS.
Hmm.
2005, 2015 and 18 total list are engaged in the matrimonial relations.
সকলোটো অকণ মন কৰি দিব পিছত লাগে অন কৰি দিব
After that. Two thousand fifteen voter is produced here.
Hmm.
WS in my petition as well as in the record also. 2015 voter list is here. But 2005 voter list not there.
In her cross-examination, she did not say that she shifted to her parents' place. See, I got married with Anwar Khan of village Dingdinga. Okay, I shifted to village along with my husband. She shifted to her parents. Her husband also.
Yes.
Documents are not even seen. The list of 2011, 2017. 17 socialist times because of my parents, my mother, my brother. Then my voter ID of my mother is 71. My voter ID is 72. These are executed. Then my evidence is at page 74. Then I was procurement at page 52. Page 52 in extra 20. My name is Samya Kapul. My is the primary resident of Birmingham. Is because I was born. Birmingham is matrimonial village. Husband village. I was born at it was the years normal. Eight brothers and sisters. And the fifth one, the first four were born at Bologna, parental original village. Part one, and the remaining, including me, were born at Dekos. My father was born at Bologna. My father died in the year 1995 at Dekos. My mother is alive. I got married with Anwar son of this Dingina. He spoke English. I shifted to village Dekos along with my friend. Presently, I am studying in Dekos. The name of my grandfather is Kanushi, and the name of my grandmother is Aisha. Brief but brief, clear, and consistency with the documents produced. There is no evidence between left. Then my mother was examined as PW2 at 56 is the C. Evidence of my mother. And my mother was examined, cross-examined at prohibition part at piece 90. That's a 22. There are 8 sons and daughters born out of wedlock with my husband. My husband died about 6 years ago at Higdwacher. My father-in-law died in the year 1982. Opposite party is my daughter. She was born at Higdwacher. Opposite party got married India. And presently the opposite party is living with us and Higdwacher along with her husband. My name entered in the voter list of 1979. My father-in-law's name entered in the voter list of 1779. My father-in-law's name is and also very consistent statement supporting the government's police and the needed part of the system. Then my brother was also along with his voter with me in 2017 voter list. He is also examined as PW 3.
ভরে দিয়ে ঠাইটো
Supporting
কি নে
the claim of
এনেকে বেকাকে বলব লাগছে
then
ঠেলিব মন
one will of the class examination is recently approved card of the exhibited.
নয় ইহঁতে কি কয় ন
Where
না মন কেছ থকা যেন লাগিছে
father's name is mentioned. Then whether his voter ID in his evidence cross-examination part at page 99, next 26. Opposite party is my sister. My mother is alive. Her name is Basia Kasim. Opposite party got married with Anwar Khan of village India, presently residing with us along with her. So there was consistent. Then whether evidence of the school teacher. Whether here I have already read. I am the headmaster of Rakashini LP School of Burma, working since October 2010.
That we have read. That we have.
Only is that the certificate was countersigned by the GO, the letter party, and his name in the admission register, his name is Samia Begum. But certificate issued Samia Khatu. That is there. That must be inconsistent. Otherwise, the admission register is clearly supported the claim of the commission. Even if the certificate is included.
What is your explanation on delayed signature by the BEEO?
Well, delay of countersign. That has not been explained. That is there. Even if my lord certificate is ignored, the school admission register and the evidence of the headmaster, my lord, there is nothing inconsistent. Fully supported the claim of the so, my lord, this is the all about of the petitioner's case. My humble submission is that the proceeding has been initiated by the learned tribunal without considering the inquiry reports. The LBO reports having no materials to sustain as a foreigner of any category. And the inquiry report is totally blank. In fact, it cannot be said as an LBO report means ordinary. Corporate criminal means he should be personally contacted. He was not tested out.
That you have already argued. Where was?
About the case and proposal, this proceeding is not maintainable because of being mechanically referred and taking cognizance without due consideration of the main grounds. Then whether the parents, grandparents, grandparents are put in 1966, 70, having land documents also. Land document has been discarded, saying that it is not proved as per law, as per evidence. Well, it is a more than 30 years old document, certified to be. It's not required to be proved by calling witness. So therefore, the time my lord evidence has been discarded illegally. Then my lord, and my evidence that my grandparents entered in 1970. My father is Bhutan with my grandparents in 1979. My mother is Bhutan in 1979 with my grandfather, and mother was examined, brother was examined. So my linkage to the evidence of my mother and brother is established in view of the section 50 of the Evidence Act. The Dolgovinda case and Suzavali case will apply. Dolgovinda case, paragraph. Dolgovinda case, paragraph. In the case paragraph 6, Daniel is voted as in the case AIM 1959, if you put 914.
Yeah. How have you established that this Samira Nisa and Samia Begum, Samia Khatun are the same person? Because the reference, we are just loud thinking what we are discussing. Reference, just listen to the question. Reference was again Samira Nisa, wife of Anwar Khan. Okay. Now, you are using the document of one Samia Khatun.
One thing is to be kept in mind. The LBO report is a report without any cases.
We are not on the LVO report. We are on the referral order.
The name is recorded as Samiran Nasa.
Yes, we are examining a reference against Samira Nisa.
My lord,
You are using the documents of one Samia Khatun.
yeah,
And now what is there to show that Samia Khatun is the same person?
my lord. Samiran Nasa in the LBO report or notice, Samiran Nasa, wife of Anwar Khan. Anwar Khan is my husband. My lord, and the LBO report has been prepared without hearing me.
Mr. Sikdar, do not go to the LVO report. Have you shown anything to show that Samiran Nessa and Samia Khatun is the same person? You're using documents of Samia Khatun. Such a perfect case you have built up for Samia. Samia Khatun is not a foreigner. There is no reference against Samia Khatun. But we are examining a case of Samiran Nissa.
The LBO report has been wrongly mentioned in some minutes.
You are not answering the question.
The name of Samira, but upon me. That is the problem.
It is served upon Samiran Nissa, but you are using the documents of Samia Khatun.
My name has been wrongly.
Where have you stated that these are the same person?
My lord.
You are using the documents of somebody else, Mr. Sikdar.
Lord, if the reference.
How can it be so perfect a case from grandfather to this thing? This has raised a very pertinent issue. And the main document of 2015 voter list. Now see page 66, 2015 voters list. That is the main document. That where you are already that is against Samiran Nessa, not against Samia Khatun.
Yes, I have a statement, paragraph 24 of the document, that my opposite party is correct and action with Samia Khatun, which is recording in all our official and non-official documents, including.
That is what we are asking you.
Yes.
Documents are of Samia Khatun.
Including the electoral roll of 2015, election village Dinginga, and it has been recorded as Samir Nessa. If in my absence, my name is written by the LBO or the electoral ERO wrongly, then what I can do? This is unknown to me. I am not there. But my name is written there, Samir Nessa, and behind my back. And notice was start up to me. Notice should be start up in Samir Nessa. But SRP's name Samia Khatun and Samir Nessa indicate the same and one identical person. That please there. Because notice has been served to me. I have a plea that because my husband.
Your affidavit is Samia Khatun. You are using the name of Samia Khatun. References against Samiran Nessa.
Things should be holistically considered. My husband name is written against Samiran Nessa. That my in-laws family members, along with my in-laws family members. So that name is written behind my back, therefore the name was wrongly written there. So that should be considered. That my name was written there wrongly. That person is directed against me. My plea is reasonably and correctly that Samya and Samya Khatun is one and same person. That I have made a plea.
Where?
Paragraph 24 of the case. My lord, in page, it starts from page 36 of the petition. And the relevant person at page 37.
The records contains the WS in original.
Yes.
We'd like to see that. This will be nicely typed out, even the affidavit. See the page 50, page 40, page 44. Page 40, even this solemn information is typed out. Why is it typed out? We'll see what is there in the original. How is it signed?
No.
Normally, you do not type out like this. Normally, you give a photocopy of the.
My lord, I have therefore made the manageability of the proceeding.
Samia Khatun.
This proceeding is evidence. What is the requirement everywhere? Is there Samia Khatun? Good DNA. Proceeding is not against Samia Khatun. Samia Khatun is an Indian citizen.
Yes.
Commission this. They're using this.
2005
15 of course.
2005 case, she was with her husband.
Hmm.
And not he is not.
Yes. Sir. Yes. 2005. 2005, she had attained the age of the
19 years.
19 years.
My clear, madam.
You are very clear. We are also very clear. We are also very clear. 2005 is a very crucial voters list. 2005 is a very crucial period. That you should have made it available. Burden is yours under section 9.
Burden, my
But
burden
you-
is to establish linkage with my
No,
parents.
2005 you have given the.
You have-
No, Mr. Sigdar. No, Mr. Sigdar. Mr. Sigdar, 2005 voter list you have produced. It doesn't contain your name. It contains the names of a family which you are projecting to be your family. 2005 you have attained the age of voting. Your name is not there in that voter list. It's a very crucial voter list, 2007. Names of mother, brother, wife of brother, sister, all are there. Even Rup Bhanu's name is there, who is just 20 years.
No. This Rupanu is my,
I know, he's the wife of Umaid. We are not saying he's his sister-in-law. We are saying wife of Umaid. Even a person of 20 years is there, your name is not there. Why?
my lord. My-
You tell us, you narrate as if you came back to the
My-
parental house.
11, I have aged about 25 years in the total list.
Yes.
So it is not, whether it is not listed in the voter list earlier to that cannot be met.
2011, Samia Khatun is there. We are not doubting Samia Khatun.
Yes, sir.
We are examining the case we have repeating of Samir and Nessa. You are using the documents of Samia Khatun against whom there is no doubt at all.
My lord, Samiran Nessa is wrongly written my.
We'll answer that.
Written by the.
We'll
my lord.
we'll answer that. We'll answer. We'll answer that. We'll answer that.
Therefore, that this reference is bad because of mechanically referred and without any investigation.
Okay, we'll answer that. Yes. Hmm? Okay. Okay.
My lord, I have one document I have to refer. Initially, 4116 of 2019. I have only one copy.
Doesn't matter. What is this reference?
4116 2019.
6 of 19.
Initially versus Union of India. Here,
Name the date of
judgment dated 27 to 2020. Here,
how do you spell IDRIS? IDRIS. Idris, how do you spell?
IDRIS.
H is there. Okay.
My lord, here there is one line in paragraph in page 5 of the judgment that reverting to the case in hand, the speak rule of evidence are not applicable in a tribunal. Nothing is required to prove one all reasonable doubt. To find that the obligation of the tribunal pertaining to existence is perverse, and then the entire opinion of the tribunal suffers perverse. The opinion must not sustain. So, my lord, speak role of evidence is not to be applicable.
Yes.
Against one forbidden lordship, and proceeding has using the document of Samia Khatun lordship and trying to establish her link with her projected father Ahmad Ali lordship. Even lordship, if we see the WS and evidence lordship, he admitted that he is the her name is Samiran Nessa because it was filed in the name of Samiran Nessa alias Samia Khatun lordship. Then Lordship, only link document Lordship here is school certificate Lordship. School certificate Lordship. Samia Khatun. Page Lordship. In record it is 64. School certificate from
School certificate, yes. School certificate is 42. 42.
Yes, Lordship. So Samia Khatun, Pita Srijut, late Ahmad Ali, here, Lordship, Sorgio, village, Dekadhua, Mornoy, গোৱালপাৰা ৰাক্ষণী প্ৰাথমিক বিদ্যালয়ৰ দ্বিতীয় শ্ৰেণীত পঢ়িছিল 1991 চনৰ ডিচেম্বৰ মাহত অনুষ্ঠিত নিম্ন প্ৰাথমিক চূড়ান্ত পৰীক্ষাত উত্তীৰ্ণ হৈছে তেওঁৰ জন্মৰ তাৰিখ 15/8/83 to Lordship, he left the school in the year of 1991. And Lordship, if we see the evidence, Lordship, Samia Khatun's evidence, Lordship, in para 14, that my father, Ahmad Ali Kanu Sheikh, Ahmad Ali, son of Kanu Sheikh, died in the year of 1995. So in the year of 1991, he was alive, Lordship. But this certificate was issued, Lordship, in the name of Samia Khatun, daughter of late Ahmad Ali. Lordship.
Now, when did, what is the paragraph you have just mentioned? Where did you say?
14 of the evidence of the proceeding.
Acha, he died in 94.
95.
That my father Ahmad Ali, son of
Hmm.
Kanu Sheikh, died in the year of 1995, and my grandmother Aisha Khatun also died in the year of 1995.
Paragraph
This-
14 of the written statement.
No,
No,
DW,
no, evidence, Lordship.
Oh, evidence.
DW, page 74 of it.
Hmm.
Paragraph 14.
Apart from that, Lordship.
Just a minute. Let us check. Paragraph 14 of 77.
Acha, father died in 1995. Hmm.
Am I correct, Lord? So, Lordship, if we see the evidence, Lordship, Lordship has already, my learned senior colleague has pointed out, Lordship, in the school admission register, Lordship, it was in the name of Samia Begum, not Samia Khatun, Lordship. And headmaster deposed in this respect, Lordship.
Page. Headmaster deposition is 102. Let us see. Yes. The name of one Samia Begum.
Yes.
Correct.
Lordship, what headmaster had stated, Lordship, a opposite party submitted an application on 15/11/2010 praying for a school certificate, and accordingly, after verification, the certificate was issued. But after verification, he issued a wrong certificate, Lordship, in the name of Samia Khatun, Lordship, and it was not properly verified as per evidence, Lordship, and document. So, Lordship, apart from that,
Just a minute. This is interesting. Oh, crossword kore dohon. The name is Samia Begum.
ইয়াতে কৈছে খাতুন
Hmm.
certificate.
Certificate kon Khatunot dile.
Hmm.
Register from Samia Begum likha ase.
Hmm. He issued it in the name of Samia Khatun.
Hmm.
Okay, aforesaid is a
Bravo.
So Lordship, another aspect, Lordship, this petitioner left the school in the year of 1991 and certificate was issued in the year of 2010.
After
So,
almost 10-20 years.
Yes, Lordship. So such belated issuance of certificate also creates a doubt, Lordship, regarding genuineness of this certificate, Lordship. Apart from that, Lordship, this certificate, Lordship, at the top of the certificate, state emblem was used, Lordship. So headmaster of a LP school, Lordship, not authorized to use state emblem at the top of such kind of certificate, Lordship. It is settled law, Lordship. On earlier occasion, I have submitted, Lordship. So, Lordship, if document itself is not,
But we have also responded to you.
yes, yes,
The mere use of the state emblem may not make the content
Yes,
clear,
yes,
visible, and
Lordship.
evidence.
yes,
That may be
Lordship.
an improper use of a state emblem. But we are examining the contents also.
Yes, Lordship.
Oh, it's not the case the state emblem, we see the state emblem, the entire document goes. It's not like that.
Yes, yes, yes.
It's an
That's
improper
not
use.
like that.
We are looking into the contents.
Yes,
Whether the contents are trustworthy, credible, and can be taken as evidence in
Yes,
favor
yes,
of
Lordship.
any of the parties.
But Lordship, evidence itself says, Lordship, it is in the name of different person, Lordship. So, Lordship, regarding rebuttal, Lordship, what our High Court has said on earlier occasion, Lordship, 2018 for GLT 360.
2018.
For GLT 360.
Mm.
Connected WBC number is 2641 of 2017.
Paragraph, name of the parties and
State of
paragraph.
Assam and another versus Ohab Ali. OHAV, Ohab Ali.
What's this? Wahab.
Yes, Lordship.
Spelling?
OHAB.
Ohab. O-H. Paragraph?
Paragraph 16, Lordship.
16.
16, Lordship.
16.
On the other hand, from the impugn order, we find that after narrating the case projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mandal reported in 2013 1 GLT 809. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevancy to the fact in issue. By mere filing of document without examining its admissibility and without the documents being proved or without examining its relevancy, it cannot be said that proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which are relevant. Lordship. So, Lordship, rebuttal is not always necessary if proceedee itself files an inadmissible document, Lordship. Then, Lordship, regarding LVU report,
Yes,
Lordship.
yes, that is one point you have to clarify.
Yes, yes, Lordship. So many cases has been held, Lordship, in this regard, Lordship. And Lordship, recently 2025 to GLT 1058. This is the repetition, Lordship. I have only one copy.
2025?
To GLT 1058. This is Lordship. This is repetition number 245 of 2019. Region and decision, Lordship. Para 12. On the basis of the submissions made by the learned counsel for the petitioner, two following points of determination arise for decision in this case, whether the reference which is based on LVO report as forwarded by the ERO, wherein certain paragraphs oblique columns were left unfilled, vitiates the proceedings before the foreigners tribunal, whether the impugned opinion is otherwise liable to be interfered with. So these are the points discussed, Lordship. And para 17, Lordship. Earlier, Samuddin's case has been discussed, Lordship. Where guidelines of Election Commission of India, Lordship, it was also discussed. Para 17. (17, 18), Lordship. Then one Amina Khatun's case has been differentiated in this case, Lordship. Lordship, para 21 is more important. In the present case, the proceeding which were hitherto pending before the illegal migrants determination tribunals were transferred by the Supreme Court of India to the Foreigners Tribunal by directions issued in the case of Sarvananda Sonowal Supra. This fact has been stated in para 1 of the impugned opinion. Hence, this court would refrain from making any observations on the LVO report in this case because the Foreigners Tribunals would have no power or jurisdiction to remand the reference back to the Superintendent of Police Border for a fresh inquiry by the LVO or ERO, Lordship. So everything has been discussed, Lordship, I think, in this case, Lordship. Regarding LPO, Lordship, it is complete, Lordship. Then, Lordship, if LPO report goes.
What is the citation of Shamuddin?
Something, Lordship.
Shamuddin.
Reported, Lordship.
Shamuddin is 2019 4 GLT.
Yes, Lordship.
456.
Yes, Lord.
Kurzan. I am. Oh, division bench.
So, Lordship, another important aspect of the school certificate, Lordship, this is village is Degdua, and village is Degdua here. School, regarding school certificate, again, I am coming, Lordship. This part was.
Just a minute. 2019. 4 GLT. 4, 5, 6. Informed by DB in WA 170 of 19. I can label it.
I swear to God.
Wait,
Oh,
the phone put the division bench.
Shamuddin, huh? So,
It took into a single bench.
Oh, dear.
Division there from Kursa.
Oh. What is the ratio?
Improper filling or leaving blank will not give any benefit to the proceeding.
কিন্তু ইয়াতে যে ক'লে যে IMBT Act 200 আছে তাৰপিছত check কৰিলে সেইকাৰণে তেওঁ
সেইবিলাক-
ওলাব
সেইবিলাক-
নোৱাৰে
সেইবিলাক কেছটো no, you cannot refer back.
Refer back.
Refer back. You have to
কিন্তু
proceed.
IMBT কেছৰ পৰা
Oh, সেইটো তেনেকুৱা দি voter.
বহুত
দি
শিকিব
voter,
আছে।
handwriting আছে, দি voter আছে, চব এনেকৈ কিছুমান দি voter নহ'ব পাৰে, এনেও তোমাৰ কামতে কৰিব পাৰে।
Lordship, here village is Dekdua.
Yes,
But
yes.
Proceed is trying to link with his grandparents' lordship, who was a resident of Bolotmari Sar Prothom Khanda, 1966 and 70 voter list lordship. After that lordship, there is a shifting after 79 lordship, as per their statement, there is a shifting lordship to village. Yes, Dekdua Sir. The lordship here village is Dekdua, but here is a lack of documentary evidence, lordship, by which there may have some connection between these two villages, lordship. There is no documentary evidence by the proceeding to make connection with these two villages, lordship. So there is lack of link between these two villages, lordship. Dekdua Sor and Bolotmari Part 1, lordship. Only oral statement is there, which is not enough, lordship.
That shifting is there in whose statement?
Lordship, in written statement, they have.
It is
stated,
there.
lordship. Yes, lordship. They have pleaded, lordship. But pleading is not enough, lordship.
Can you tell the paragraph?
Yes, yes.
Shifting to Napal.
12. This
12.
Acha.
nearby village, Dekdua Sor, previous village, Bolotmari Sor.
What is the submission you are trying to make on the change of village?
Lordship, mere statement is not enough, lordship. These are only oral statement, lordship. There is no any documentary evidence that by which they claim that they were and then they were the resident of that Bolotmari Sor Part 1. After that, they have shifted to.
There
Dekdua
is
Sor.
one voters list of 1985.
Yes.
Uh,
Different village, lordship. Dekdua Sor.
Dekdua. Interestingly, in the earlier voter list of 1979, grandfather, father, mother. Then the grandmother was not there at page 55. Then in the next voter list of 1985 at page 57, father, mother, and grandmother.
Father, mother, and
Grandmother.
This is
And
Kalu
from
Singh, lordship.
85, there is a big gap till 97,
Yes, lordship.
10 years. And you say that there is a deposition that her father had passed away in the year 1995.
Yes.
That means 91, the father's name should have been there somewhere.
Yes, lordship. And lordship, where schools in school certificate, lordship, it was recorded as late Ahmad
No,
Ali.
that is what 95 he was there. He
Yes,
passed
lordship,
away.
and
91 he
should
was
be there.
there. And
He should be
91 there is
there.
no voter list.
Yes, lordship. He should
From
be there.
85 to 97, 12 years.
Yes. There is a huge gap. After that, lordship,
Sona Bhanu, Basia Bebas. Basia Bebas, Sona Bhanu.
only voter list will remain, Lordship. Regarding sister list, Lordship, I want to rely Aziz Mia's case, Lordship, 2023 4 GLT 246.
Just a minute, just a minute. Bacha Namgir, 2005, 97, 10, okay, Nahaiba. No, no. Nine. 25 is plus 12. Father, father, 24 years, 1979. Mm, 79 or 24 years, right? Date of birth, one over.
Can you get it?
79 or 24 years.
Date of birth of what? 5.
79 minus 24.
55. Oh, 55.
1955.
1955 was it? 79, 69, 59.
Hmm?
55. God, it's
Yes. Yes, which one?
Then, Lordship,
No. You wanted to show a decision.
Lordship,
Aziz or something you had said.
Aziz Mia, 2023 4 GLT.
Why, what purpose?
For voter list, Lordship.
Means, what is this idea?
What paragraph 14 has?
AZIZ.
Yes, Lordship.
AZ.
AZIZ. Aziz Mia, MIY. Alias Mohammed Aziz Mia, AZIZ, MIA.
Citation?
2023 4 GLT 246.
246.
6. Connected WBC number 2370 2023.
It's okay. Which paragraph?
Para 14, Lordship.
What
We are
is-
constrained to observe that mere claim by a suspected person by referring to a voters list claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person
Correct.
who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So, Lordship, in this case, Lordship, if school certificate goes here, if only voter list is not sufficient, Lordship, here in this case also, Lordship, petitioner failed to substantiate his claim by producing some further materials by which he can establish his link with his projected grandfather or father who is existing prior to 1970 or 1966, Lordship. So, Lordship, if voter list and school certificate goes, Lordship, there is nothing to link with her projected parents, Lordship. So, that's all, Lordship.
Okay.
Mm.
Yes, anybody would like to join anything? Anything like to rejoin, Mr. Peter?
Here, my lord, my friend, like assumption that the name, list and there is shifting explanation is not sufficient. But the Supreme Court in the Sirajul Haq case has held that name discrepancy and shifting of residence cannot be ground to doubt one city. And how that can be overlooked by the Supreme Court said. One point. And even if the certificate, school certificate is not considered, the evidence of this teacher, based on the admission register, how that can be ignored? That is one point. And my evidence of based on
But
my
admission register has got another name.
I have explained that there are name discrepancy. So this type of name discrepancy cannot be.
No, discrepancy of the name we can accept.
My lord.
But admission register has another name, certificate given in another name.
My lord. That was a mistake committed by the headmaster, but the admission.
Had it been the case that the certificate was given in the name of Begum and you are using this, you said that by mistake they have given Begum. But Begum has not been written as Begum, it has been written as Khatun. Why? That came out in the admission register. See, you may have to, there may be some spelling.
Samia is the name. Khatun and Begum, these are the title. He has, when he applied for, perhaps he has written his name, Khatun. Therefore, the certificate was issued.
No. Certificate is not given on your application. Application is the initiation of the process. They have to check the register. From the register, whatever appears, it given a form of certificate.
There was a mistake.
Because you do not know which date you have left the school, which date you have in which class. It will be all verified from the register.
Even if the certificate and evidence of the headmaster is ignored, how the evidence of mother can be ignored? The evidence can be mother can be ignored. Other evidence can be ignored.
Those case laws are there, Noor and all those.
And there has been a specific statement that my correct name is Samia Khatun, but in the debuter case, notice has been issued in Samiran Nasa, wife of same husband, same name, husband name is same. So that name is also targeting me. So Samiran and Samia Khatun is one and same person. That we have explained. How that can be ignored? I have explained because the notice is served upon me as a Samiran, and wife husband name is same. So that variation, that variation is to be considered, and our plea that the proceeding and the whole proceeding is illegal because there was no fair investigation. The name was written in the debuter case and the LBO report is wrongly written as Samiran Nessa. That was our specific.
Mr. Sharma, why in voters list where there are also voters whose names are prefixed with D, you come to page 66 of the writ petition. On the third column, right, or from top 1 to 3, 549 is Samiran Nessa perhaps.
Yes.
Her photograph is not there. Is it like this normally or what?
It's not the certified copy, Lord.
No. We are on a different purpose. Because this would have led some
More evidence, no? More
Usually,
clarity.
it should be there, Lordship.
It should have been there.
Yeah, because in our voter list, our photographs is always there, Lordship.
This
Okay.
again raises doubt.
No.
Doubt was there, no?
The photos are available.
Well,
Okay.
regarding oral statement, Noor Begum case is 2023 GLT if 347 করছে 2020 GLT 347 para 4
Oral statement. Noor Begum,
2020 GLT 347
2023 GLT,
yes lordship
page
347
347. Okay.
My lord, I have one citation.
Yes, please.
That is 2021 3 GLT 85 Hyderabad versus Union of India. Here in this case, paragraph 46 said that all the voter lists are not necessary. If the linkage is established, legacy is established, or not punishing other voter lists, the evidence which has not been debated cannot be discarded. That is the view of this court.
But in your case, you have given all the voters lists which are not relevant. You have not given those voters lists which are relevant.
My lord, my
This will
No,
be
my-
applicable
absolutely
against you.
wrong, my lord. Absolutely wrong, my lord. I have given all the voter list relevant. The case has been made out with the 11. With 11.
See, 66 voter list, 70 voter list you have managed to
Yes.
give 79 voter list. Now, after 79, when the crucial period come, when you have become attained the age of franchise, you have not given the voter
My lord,
list.
I have furnished the voter list of 1997, where my age is 25 years only.
'97,
97, no, 2011 voter list.
yes, '97 you are not there.
Sorry, man. 2011 voter list, where my age is only 25 years. I was
And
very-
the relevant voter list before that,
my lord,
where your
2005.
name should have been there.
no, my lord, 3-4 years missing. It cannot be fatal.
No, it's not 3-4 years.
2017,
If you are aged, how many years?
I was
25 years in 2011. Where is the earlier voter list? In 2011, there is one Samia Khatun, which you project to be a self-friend.
requirement is not at all necessary because my linkage with my parents. In 17 voter list, I am voter with my mother, and mother was examined. Mother is also with my grandfather. Grandfather is voter
Okay.
in 66, 70.
Please write.
So linkage is established.
Please write. AR Singhal. Write the names of all. And G Sharma. Then M Islam on behalf of AU Ali, AI Ali. Then P Sharma for Cheat. And Madam for CGC. As Borough of CGC. Hearing is concluded. Judgment is reserved.
You did not give the last judgment that you wanted
Well-
to. The last judgment that you wanted to give on
Hyder
voters
Ali,
list. Oh,
Yes,
Hyder
sir.
Ali.
2021 3 ZLP.
3.
Yes, madam.
Hmm.
2021 3 ZLT 55. Relevant paragraph is 46.
Age is 285.
Yes, madam.
85.
2021
285 or 85?
85.
85.
285.
2021 3 ZLT 85. Paragraph relevant.
How do you
paragraph
spell Hyder Ali? H
HAIDAR. Hyder.
DAR.
Hyder
Okay.
Ali.
Okay.
ALI.
Paragraph
46.
Okay, thank you.
DW.
Item 2. But this reference has already been answered. What will happen to this kind of cases?
Then Lordship, he has to prove that before the tribunal, Lordship, that he's
Belongs to
he
this
belongs
particular
to-
community.
Yes, Lordship, yes. Lordship.
But this reference is already answered. So this advisory or whatever you say is only to the assistant government pleaders for withdrawal of cases.
Yes, sir.
Now you are not before this court. He is before this court. He is aggrieved by an opinion. Opinion is already rendered against him.
Yes, sir.
So what will happen to a rendered opinion?
Lordship,
It's up to you not to act upon the
Yes,
opinion.
Lordship,
But can we?
We are only to see whether the opinion of the tribunal is good or bad, Lordship. That much only.
No, see, this is to all of the government pleaders that if there is any reference, you can withdraw it.
Yes, yes,
Now there is no reference.
yes, Lordship.
Reference has culminated in an opinion which is before examination by us.
Yes, Lordship.
Now at this stage, what relevance will this have? Or what other procedure will you adopt? See, the intention is very clear. You do not want to proceed against the Coast Rajbangshi community.
Yes, Lordship.
But one has to prove that one is a Coast Rajbangshi community.
Yes, Lordship.
That proof cannot be done here.
Yes, Lordship.
Reference is already there.
Yes, Lordship.
So one option would be to send back the matter and but have you read this?
No.
See, read this.
Reference to subject, I am directed to inform you. The government has decided to withdraw all cases pending against the people belonging to the Coast Rajbangshi community in the various foreigner tribunals, Assam. In view of above, you are hereby directed to take necessary steps for withdrawal of such cases pending in tribunal against the persons belonging to Coast Rajbangshi community at the earliest upon completion of the process. A compliance report may kindly be furnished to this department. So, Lordship,
So pending in the tribunal.
yes, Lordship.
Now this has been addressed to the assistant public government pleaders, FT.
Yes, Lordship.
Now you have to withdraw.
Here.
Withdrawal of a pending reference. So what will happen to a reference which has already been answered? No, Ka is different. This is different. Ka is different. This is Coast Rajbangshi community.
Then, Lordship, matter maybe take a remand. Mr. Payang may have appeared in this
But
case.
see,
Lordship,
we need certain clarity in this matter.
Yes, Lordship.
We can inform you that there has been instances where tribunal members have been put to show cause.
Yes, Lordship.
Why cases have not been has not been dropped.
Yes.
But this advisory is not to the tribunal.
Yes, Lordship.
This advisory is to the prosecution.
Yes,
You
Lordship.
withdraw the prosecution.
Yes, yes,
Once, if there is no application for withdrawal,
yes, Lordship.
and second more important fact is what you have hinted at the first, that without there being a determination whether the proceedee belongs to this community, can it be withdrawn? In other words, by adapting to a surname which
Yes.
looks like a Coast Rajbangshi community, can one be a Coast Rajbangshi
No,
community?
no,
Cannot
Lordship.
be. There has to be some determination process, maybe a summary proceeding,
Yes, Lordship.
that you belong to such and such community.
Yes, Lordship.
Without that,
Without that, how do you? This has got total lack of clarity and more so when subsequent action of the department is not in consonance with this directive. Member of tribunal was put to show cause.
Lordship.
Hmm.
I know about it.
Mhm. For not
For
withdrawing.
for not dropping a case.
Oh.
He said when there is no application for withdrawal, how can I
How
drop
can
a
I?
case? I don't even know whether the procedure is course mercy or not. The surname appears to be of course but that by itself will not be enough.
Determine করবো।
All these things are, Lordship, matter of factual determination, Lordship.
Exactly.
An appropriate forum is concerned foreigners tribunal, Lordship.
Mm.
So, Lordship,
See, we have got nothing to say against a policy of yours to proceed or not to proceed against a particular community.
Yes.
We are only examining the validity, correctness of an opinion under 226. Now, if some decision has been taken not to proceed against a particular community, now this decision needs to, first you have to be clear, there has to be clarity that the decision is retrospective in effect. What will happen to those cases which have been answered?
yes.
What will happen to those cases which have been answered and
Yes,
affirmed by the High Court?
Those are not there, Lordship. in fact.
Maybe there are cases which have also been affirmed by the High Court.
Yes, yes, Lordship.
You take instructions, Mr. Chitri, let them take instructions. Okay? Let them take instructions. Hard Sri B. Chitri, learned counsel for the petitioner. Pursuant to the order passed on the last occasion, comma, Sri G. Sharma, learned standing counsel, NRC and FT, has produced a communication dated 11/4/2025 issued by the political within bracket B department. No, not Home and Political, don't say Home and Political Department, Government of Assam, regarding withdrawal of cases against persons belonging to the Koch Rajbangshi community. Para? Perusal of the communication would reveal that the government has decided to withdraw all such cases in the various foreigners tribunal. Full stop. However, we are faced with a situation where a reference has been answered and the opinion is the subject matter of challenge. Full stop. Accordingly, we direct Sri Sharma, the learned standing counsel, to obtain necessary instructions on the future course of action regarding with regard to matters of this nature. List after 3 weeks.
Yes, Lord.
মানে কি? Writ appeal.
Not a foreigner's matter. You do not do foreigner's matter. Insurance matter. Foreigner's insurance.
Item 25, supplements.
19 was ইমান motions আছে ও। D. Ghosh was there in the morning. Hmm.
Adjournment decline করেছি এবার আজি ফিক্স করছো
Short accommodation. ঠেলিব পাৰি এইটো।
ঠিক করে দিবা
না ঠেলিছো। তাৰমানে কি মই মানুহটো এনেকে বহিব লাগে। ঠেলিছো এতিয়া। এটা মই think বহিব। দৌৰি আহিব চাগে।
Yes, what is the matter? But Mr. Bhatti, perhaps we'll not have time to have your matter today because my sister has a single bench with some matters and we'll have one last hearing today. Maybe we'll rise around 2:30 or whatever time takes this matter will take. We'll accommodate you. But depends whether this matter will be done or not. Oh, yeah. It matter day after tomorrow. Koiba. Today we'll not be able to have, if the matter which you have called, that perhaps we are not adjourning. That will take some time, half an hour after that. We have to rise. My sister has a single bench. Even we have a division bench, another division bench. We can just have your matter. এইটো আগতে দি দিয়াচোন এওঁ আহি আমাক আৰু হেৰি এই চন্দন আমাৰ ৰয়ক কৈ দিবা যে আমাৰ কলিতা ছাৰক ক'ব লাগে যে 2:30মান বজাত এটা তেওঁ খবৰ দিব 2:30তে উঠিম বুলি নহয় 2:30মানত খবৰটা দিব
ঘোষ আহিছে
Just a minute, you are late, but the bus is still waiting for you. Bus is waiting, don't worry. Yes, we'll finish our matter.
26. Case 11.
Yes, when can you appear? No, not 10 days, 7 days. Heard. Heard Sri R. Ali, learned counsel for the applicant, who by means of this application has prayed for extension of time for his appearance pursuant, no, not say pursuant, in compliance with the order dated 2/3/2026 passed in the connected WPC 1181 of 2026. Full stop. The learned counsel has submitted that while issuing notice by the aforesaid order, bail was granted with a condition that the petitioner has to appear before the concerned
SP border
SP border within Sonitpur within 10 days from the date of the order. Full stop. He has submitted that due to circumstances beyond the control of the petitioner, he could not appear within the aforesaid 10 days and has immediately filed the present IA on 24/2028 for extension of time. It was 2/3. Why 2/3 10 days? Why are you so late? You could not even, you did not even come to this court within 10 days. Para, Sri G. Sharma, Leonard, Standing Council, Home Standing Council, NRC and FT, has, however, submitted that the application was not filed immediately, and therefore, immediately, full stop. He has, however, not made serious objection to the grant of time, which, however, is required to be grant of time, para, considering the facts and circumstances, and as an exceptional case, we allow this application granting further time to appear in terms of the order dated 2/3/2026 on or before. We give a date, 10 days. What kind of date did you? Today is 5th. On or before 12th of May, 2026. On such appearance, the directions contained in the order dated 2/3/2026 shall be followed. I extend this for gospel. You get the order today itself. Into Akote Mariba, huh? Yes, Madam Ghosh. Okay, we'll keep it open.
Yes.
Okay. Heard Ms. D. Ghosh, learned counsel for the petitioner. Also heard Sri G. Sharma. Then M. Islam on behalf of AI Ali, ECI, RB Bora State Council. The present challenge is against an order dated so and so, passed by the so and so and so and so, huh? Para. Notice was issued on 13/11/2019. Full stop, para. No, notice was not issued. Notice was not on 13. Notice has not been issued. The matter is pending at the stage of issuance of notice since the year 2019. Para Ms. Ghosh, the learned counsel, has fairly submitted that the client is not in touch and therefore it would be difficult for her to pursue this matter. Para, in view of the aforesaid the submission, comma, the case is closed, full stop. It is however made clear that in case the petitioner wishes to proceed to pursue this case, comma, he may approach this court with an appropriate application. Maybe notice was also not issued, therefore he must have lost all hope. 19 or matter so notice the police.
Yeah.
Item 3.
FT যিমান ফাইলিং হয় সেই
অ।
সেই অকণমান ডিসপ্লেটো বহুত কম হয় আছে
বহুত কম।
one bench is less ইমান single হলে চাগে বেছি হ'ল হয় yes item number 3 yes we'll have this as last item এটা লৈ লওঁ your AW Aman. Abu Kamal Talukdar. Abu Kalam. Kamal becomes Kalam. Okay, no problem. Which FT? Kamrup. Okay.
NRC Supreme Court is not applicable in foreigners case.
NRC will not be a conclusive document for proof of citizenship.
Did you make your detail?
Huh? That's a detail. Conclusive, no? Supporting hope, right?
Yes. Oh, please, yes.
Yes, page 43. You come to the vernacular at 44. 1960. Dil Muhammad is who? Grandfather. Okay. And Hazira Khatun? Grandmother.
There is a shifting letter.
This is really Bali Kuri non-K. Non-K. Okay.
Next, 45 is 370.
Dil Mohammed.
That voter list. This is more public, no.
Dilomia.
Son of a village, son of Ate, also the name of house is also the same. There are maybe but the age was not matched. 1970 was 64, there is 80. 10 years later.
Okay. What is your date of birth or year of birth? 1978.
Was born in this village. This was born in Bali.
Okay. Thereafter.
Ataur Rahman,
So who are these Ataur?
Son of Hilo.
not your father.
Father name is Abdul Rajab.
Thereafter, 1989.
Abdul Rajab is the father. Son of Hilo. And the same village.
Exhibit F or E? E, I think.
The mother's name is Mubilon Nessa.
Your father, mother died. Oh, grandfather, grandmother died.
But
Hmm.
I presume the same village, the house numbers are different.
Hmm.
Because they were living in the same village. That's why in the
But your father, in the voters list of 1989, his age has been shown to be 34 years. Meaning thereby that he was definitely a voter in the earlier 85 or 80 He's 34, sufficiently, he's crossed the age of voting. But there is not a single voters list of your father along with your grandfather. And this 89 voters list will not be of much relevance unless you can establish a link with with a voter list or any document prior to 1970.
The father name also matches. So that's
No, father, for a moment, let us assume that Dil Muhammad and Dilo Mia is the same person. So that you're trying to establish a 70 voter list with a 1985 voter list. 15 years gap is there. Then your father comes in, but there is no connection of your father with your grandfather in a common voters list. That is the difficulty.
my submission is that because the father name is same in the same village, we cannot be that confident that the same father name would have that you have another person. the
No,
same-
this becomes Dilo. Grandfather's name becomes Dilo. So far as page 49 is concerned. It is neither Dil Muhammad nor Dilo Mia.
This father, so the case is not the first name is referred.
No, that we are not being too technical. But what about the gap? Huge gap of 70 to 85. Then 85, you have a voters list where father does not, your name of the father is not there. You can justify that 89, your father was living separately in a separate house. So father's, mother's, parents' names are not shown in the same list along with your grandparents and uncles. But 85, that is not your case. 85, your father was already more than 21 years of age. Mother was there. You were born in the year 78. That means the marriage was much before
78 he was already born.
born. And this is a voter list in the period of 85, 86, 88, 89.
In the 50 years, the family submission is that the age matches was 64 in 1970, 1980 he becomes 80. And it's the same village. There's a name, the Gauhati and the father name is same, the wife name is there. Just Dil Muhammad becomes Dilomia.
But the link of you and your father.
Because dates document which you are 19 voter list page you 50 million.
May not be very relevant.
Here there is a shifting was mentioned the WF of the mother reports from a different village in complex.
The 97 voters list, Nabia Begum and Nabira Nessa are the same person. She's not Bewa here. Normally Bewa comes. Nabia Begum. Man difference, Namdu.
But see the difference in the age.
Hmm.
Age, she was 29 in 89. In 97, after how many years? 8 years.
Hmm.
The age increases by 2 years.
Hmm.
This is a different person.
Explaining the WF.
Name change. Name earlier was Nabi Run. Nessa, Nessa becomes Begum. Nabiran becomes Nabia. Village becomes Bogranda.
Hmm.
Mentioned the WF.
Difficult.
Abdul Razak became Razak. But in not the earlier list.
No, you can omit the surname. You do not omit the name. Reza can be a surname, Reza can be a name. Now his name was Abdul Razak. Now here Rejak is written, only Rejak.
Surname, or you can say pre-name. Result is the main name.
Then what about Nabia becomes Nabiran? Begums becomes
She appeared for the
it's too much of a mismatch. Now, first time Abu Kalam Talukdar comes into the picture in 1997. When did your father pass away? Yes, what else? Yes, Mr. Aman. Then what is the next 2005?
It is the same village.
Who's there?
Mother is there. Is there.
Nabia Begum.
Who is Rangmala Begum? Not been explained.
Motalib.
Motaleb Talukdar.
Abu Kumar.
Here you are said to be the son of Nabia, not Rejak. Father's name is missing.
Maybe the enumerator was a lady. Maybe the enumerator was a lady. Rangmala Begum. Rangmala. Who's Rangmala? Who's Motalib?
Talukdar matches.
And see the serial numbers 173, 175. Even before the son, Rangmala comes. 18 years.
Double.
Village to কি?
Village to এটা shift হল বলে বগ
ভোগ্রন্থ
বালিকুলি পর shift হল
There is the elder brother, one of the brothers.
Motaleb.
Motalib elder brother of whom? Younger brother.
Any statement to that effect?
One mentions that one of the brother is Mr.
Okay. তাই তালুকদাৰ এটাই ৰেহমান পুতেকৰ মাজত কৰি থকালৈকে নামকেইটা বেলেগ ভগৱান হোৱাৰ লগে লগে নাম
This Motiar Rahman is your brother. He is 25 years of age in the year 2011. Correct?
Yes.
25 years. At page 55.
Yes.
So his name ought to have been there in the voters list of 2005. It's not there. But see, we are more on the crucial period of 70-71, and you have to establish a link since you are born post 1971, the cutoff date. You have to show a link either with your parents or with your grandparents with clinching, credible, trustworthy evidence. And the link has to be established by documentary mode. You establish that and you have an order. See, later will not be too much relevance. Relevance only for the purpose of having a continuous link. But we are more on the aspect of 70-71.
Establishment was that the father's grandfather's name till 1985, and then 89 the father's name is there, the grandfather's name matches, and then the subsequent voter list in 1997, the father's name is there. But there are variations. It's my respectful submission is a normal phenomenon in the electoral rules.
No, see, there is a big problem we'll face. We are on the crucial period of 70. Prior to that, you have somebody projected as your grandparents, and it continues from 1966. 1960, Dil Mohammed and Hazira Khatun. 70, Dil Mohammed, Hazira Khatun, no problem. 85, Dil Mohammed becomes Dilomia. We, for a moment, let us assume that Dil Mohammed Dilomia is written because Hazira Khatun and the age also appears to be slightly consistent. There are two more persons, one uncle, one aunt, 26 and 22. Your father is not there. Your father comes just 4 years thereafter in 89 with the age of 34. And it is only through your father by which you are trying to establish a link with Dilomia alias Dil Mohammed. Now this link is not there in that crucial period. The voter list of 85 and 89 are proximate, 4 years. Father's age in 89 is 34 years. Where was he while he was 30 years of age, 29 years of age? From 2018 to 30, there's nothing. And here, 89 voters list, also we would have taken into consideration had it contained the name of your mother, grandmother, or even Dilomia. Dilomia, suppose he passed away, grandmother was there.
The different house.
No, household becomes different in 89. What about 85? No, then where was he? No, then where is this voters list? Had it been, had his age been on the age, like 20 years, 19 years, we would have, that his voter name was not there, enlisted in the voters list. His name was enlisted on at least on 2 occasions, if not 3.
Same village, same name, father's name.
That is different. Abdul Razak, somehow he comes into the picture with the age of 34 in the year 1989. You should be glad that Abdul Razak is not facing a proceeding.
And the house number is also different.
Abdul Razak is no more. No, that is a probable case. House numbers being different in the year 1989, but 85 to 89.
Scenario will not that they both have been in the same house, but they are not. That's the case with the
Now even 85 household might have been different, but 85 your name has to be there. Where is your name? Household, your explanation, whether we accept or not, you could have an explanation. We have, after my marriage, I had started living separately, so I have different house. So my names are separately there. But suddenly you enter into the scenario of voters list in 1989. Your father rather.
not helping. But even though my case is that because in same village, or the name
Different, very difficult. Very difficult. Anything else, Mr. Aman?
Augura member. It's for the subsequent, the last piece of the explanation. He is Augura, decision number not 81. See that opposite partners of the village, Uganda from village Balipuri to
Age 81. Where is his certificate?
each number below, particular case number 65.
Date of this? 310. 31018. Certificate by Gauhati. ইয়াৰ দ্বাৰা প্ৰমাণ পত্ৰ দিয়া হয় যে আবু কালাম তালুকদাৰ পিতৃ আব্দুল ৰেজাক গাঁও চোৰেঞ্চ মৌজা চোৰেঞ্চ জিলা চোৰেঞ্চ উপৰোক্ত মানুহজন ভোগ ৰন্ধা গাঁৱৰ লোক হয় বা মানুহজন ল'ৰাজন ছোৱালীজনক চিনি পাওঁ উক্ত
কথাখিনি
সত্য And his deposition is at page as DW. Okay.
He,
This line.
Hmm.
The document part is, is already been paid. Not know why they have not been released. Village, Oakland's 1992, 91, 92. The parties of this, would represent. This helps my case.
he was not cross-examined.
Now, your questions were put to by the tribunal. There was no cross-examination.
So that is 165, not
165.
cross-examined.
Tribunal, correct. Okay, any case law you'd like to cite? Any case law you'd like to cite? Yes, Mr. Sharma.
My humble submission is that there is no infirmity in the opinion passed by the learned tribunal, Lordship.
Hmm.
Lordship will kindly see the last part of the page 28 of the opinion. Name of Abdul Razak, second paragraph. Name of Abdul Razak appears in the voter list of 1989 at the age of 34 years, and the name of Nabiran Nessa appears in the same voter list at the age of 29 years. A person attains the age qualified for inclusion of his name in the voter list.
Wait,
at
Mr. Sharma.
Lord,
Wait.
Page,
We are yet to take
page
up.
28.
Same thing which you have pointed out, perhaps 34. Why 34? Page 28, which
Says-
paragraph?
Lordship, page 28, second paragraph, Lordship.
Name of.
Name of Abdul Razak appears in the voter list of 1989 at the age of 34 years, and name of Nabiran Nessa appears in the same voter list at the age of 29 years. A person attains the age qualified for inclusion of his name in the voter list at 21 years prior to 1st April 1989. From 1st April 1989, qualifying age for inclusion of a person name in the voter list is 18 years. Abdul Razak attained the qualifying age 21 years in 1976, but failed to submit any voter list or any other document containing his parents' names along with persons whom he stated to be his grandparents. So, Lordship, if we see the voter list, Lordship has already pointed out 1966 voter list of Dil Mohammed projected parents and grandparents, page 44.
Hmm.
Projected grandparents here. Then Lordship 1970 each of same village, same voter list, Lordship.
Hmm.
Projected grandparents' name appeared along with his uncles. And then Lordship, after that Lordship, there is a huge gap of more than 15 years, Lordship, 1989 voter list. Here, Abdul Razak's name first time appeared. He was aged about 34 years. If he is 34 years in the 1989, then his date of birth would be 1955, Lordship. And
Hmm? But he says his date of year of birth is 1978. Oh no, not Abdul Razak. His father, correct.
So, Lordship, here he attained his voting right from the year 1976, but till 1989 there is no voter list, Lordship. So, Lordship, if we see this Abdul Razak and 1966 voter list of Dil Mohammed, there is a lack of link between these two persons, Lordship, father and grandfather. There is no document to link themselves, Lordship, to each other, Lordship. Apart from that, this is although this is the same village, Lordship, then after 1989, Lordship, Proceedings name first time appeared, and connected person is Rajak, and here mother's name changed to Nabia Begum, Lordship has already pointed out. And next voter list is up to 2005, Lordship. Here also Nabiran Neta becomes to Nabia Begum, and Lordship connected persons of the proceeding, Lordship. Here not Rajak, Nabia's name reflected, Lordship. So Lordship, only to link themselves, they place Gaubra certificate and Gaubra adduced evidence. What Gaubra has said, Lordship, I have issued the residence certificate exhibited as Exhibit M in the name of Abul Kalam Talukdar, son of Abdul Razak of village Bhukrandha, post office Gajia, PS and district Borpeta. He is a resident of my village. Exhibit M1 is my signature, and the exhibit opposite party has been shifted to village Bhukrandha from village Balikuri Nonke. I do not know why they have come to this village. The opposite party has been residing at village Bhukrandha since 1991-92. The opposite party has been casting his vote regularly. I know the opposite party and his father, as he is the resident of my lot. So, Lordship, since 1991 and 92, this Gaubra knows the proceeding, Lordship. Prior to that, there is no connection with this Gaubra, Lordship. And Gaubra of earlier village never come forward to the tribunal, Lordship, to adduce his evidence, Lordship.
But the issuing authority is the same.
Yes, Lordship.
The DW3 is the issuing authority.
Yes,
Panjit Patwari.
Yes, Lordship. Gaubra of this village, Lordship, where they have shifted from Balikuri Nonke, Lordship. Gaubra of Bhukrandha village issued the certificate, Lordship. But Lordship, Gaubra of Balikuri village, Lordship, never issued any certificate. Which is
Are you trying to say that it is the certification would be valid only for a period from 1991?
Yes, Lordship.
Which we are not concerned.
Yes.
We are concerned with a period
Absolutely, Lord.
between that crucial year of 71.
Yes.
Either him or his father or his grandfather should be
Yes.
known residing in India before the crucial date.
Yes, Lordship. So, only part is remains is that lordship if voter is lordship one earlier this lordship first up I have cited the Argentinian's case lordship. Again I am want to rely on this case lordship. In 2023 4 GLT 246.
4 GLT.
246.
Ajizmia.
Yes, lordship. Para 14 I am relying lordship.
AZ, IZ.
Yes, lordship.
Para 14.
Yes, lordship.
1-4.
Yes. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged his burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter's list relied upon this actually the father of the person who makes the claim. The claim will have to be substantiated with further material and materials acceptable in law. So, lordship, in this case, there is a lack of such materials by which petitioner can substantiate his claim that he is not a foreigner, lordship. Apart from voter list, if Gaura's certificate goes, lordship, nothing will remain. So, lordship, my humble submission is that petitioner in this case totally failed to establish his link with his projected grandfather, whose name reflected in the voter list of 1966, lordship. That's all. My submission.
What's for you, man? আর আমি মজা নেই আমার একটু পরিবর্তিত নরেন্দ্র মোদী এটা করবো তুমি লিখিবা
Itu.
70 to 85 like a 15 years gap, unexplained gap. First time he has come on 90, father has come with 34 years. He should have been, there is no voter list of father to establish. Even to establish, there is no voter list at all. How the father came into picture, nobody knows. In the year 1989. Once father was inconsistent. Name be like inconsistent আছে A.W. Aman, G. Sharma, N. Kolita, ECI, R.B. Bora, State Council, S. Borwa, TDC, hearing is concluded, the point is reserved. Any matter which has some urgency, court must will give date. The second division bench will sit by around 3 o'clock.
This case, we are seeking some adjournment for today.
When can we have?
In the first week of June.
These are with connection with which matter?
Also, this is it is from San Marino.
Sunmary. Same connected incident.
No, not connected. Other one is from Sabua.
Understood? No. The main route is the same. CA. And they are, this is the revision is against which order?
Order framing charge.
In that case, the state had come against the order by which charges were not framed. Now you are aggrieved by framing of charges.
Initially, your lordship, in this case also, we were discharged, your lordship. Then the state
Remanded.
Then remanded back the matter. Fresh hearing conducted and then charges framed.
Okay, but we'll say when, as and when the bench will be, but Adjourn for a week, list as and when the bench is.
Lords.
You are seeking the adjournment.
Lords.
Where is your assisting counsel?
He is here.
Otherwise, will not allow you to
No,
argue.
no, he is here. Nalaga hat, final.
Now you cannot argue alone.
Lords.
Heard Sri S. Bothakur, learned senior counsel assisted by B. Hussain. For the petitioner, also heard Sri K. Gogoi, learned special PP, NI. Para. Sri Bothakur, the learned senior counsel has prayed for some accommodation. Full stop. The aforesaid prayer is not say aforesaid. The said prayer is not opposed by Sri Gogoi. Para. In view of the above, matter is adjourned to be listed as and when this bench would be available.
Lords. Lords.